Hello there, and welcome to Windward's Executive Education Program. We are excited to bring you the first ever global series on sanctions compliance for shipping. We are privileged to have with us leading legal experts from London, Washington, D.C., and Hong Kong. These partners at Blank Rome, Ince, Reed Smith, and Steptoe & Johnson together have over 100 years of experience in this fast-changing area. So Windward is grateful that they agreed to share their valuable time with our audience and that we could bring you this complimentary program. Speaking of our audience, you'll be interested to know that to my knowledge, this may be the largest sanctions compliance event of the year, and certainly the most diverse. There are over 1,000 registered attendees representing over 300 unique companies coming from 30 plus countries spread over 6 continents. We'd like to give a special welcome to our attendees from Cook Island. The entire maritime ecosystem has showed up, including shipping, insurers, financial institutions, commodity traders, and maritime authorities. We all understand that it's beyond compliance. It's about how we turn managing risk from a business blocker to a business enabler. I'm Michael Horwitz, Head of Commercial Product Marketing at Windward, and I will be hosting this session and the whole program. I'd like to remind you that this session is one of 3. By attending all 3 sessions, you will get a complete view of the challenge and gain the tools to meet it. If you are not able to attend one or more of the sessions in person, you can watch the recordings and still receive the certificate. Speaking of recordings, based on popular demand, we will extend a special permission to invite your colleagues. They can catch up by watching the recording and join us for next week's session. Many organizations suggested that their entire team can benefit from this educational program. If you want to make this into a departmental or company-wide event, please get in touch with us and we will try to accommodate you. A few words about Windward before we begin. Our vision is to digitalize the maritime ecosystem to help organizations achieve business and operational readiness by making future-forward decisions. The largest countries in the world partner with us to secure their maritime borders, like the US, EU, and other major countries in Southeast Asia. Over 75% of the world fleet is insured by Windward clients. Recently, organizations like banks and oil companies looking to elevate their compliance have turned to Windward to proactively manage their exposure to maritime risk. When it comes to managing risk, it's all about trusting your partner. The best in the world rely on Windward's insights and technology to understand what's happening at sea, both the known and unknown invisible activities happening every day. This educational program is another way we are contributing to the success of the maritime ecosystem as we collectively raise our standards of transparency and accountability. We are thrilled to bring you Mr. Nick Turner for our first session. Mr. Turner is a leading sanctions compliance expert and lawyer at Steptoe & Johnson in Hong Kong. Over the course of the next hour, he will give you an overview of the latest shipping advisories and help you understand how they are driving new standards for sanctions compliance in the shipping sector. Please send in your questions by clicking on the Q&A button at the bottom of your screen. In the interest of privacy, we won't reveal your full name or your company unless you specifically indicate otherwise. We'll of course try to get to as many of your questions as possible in the Q&A part of the broadcast. And now over to Nick.
Thank you so much, Michael. I'll just share my screen here. How's that?
Looks good.
Wonderful. Hello, everybody. Good morning or good evening or afternoon, wherever you happen to be. Thank you so much for joining us for this first in a series of 3 trainings. We'll be talking about the latest shipping advisories from the United States and the UK government and how they're driving new compliance standards. As Michael said, my name is Nick Turner. I'm a lawyer with Steptoe. I'm based in Hong Kong, but our firm is based in Washington, D.C. I've included a link here to my LinkedIn profile. If you'd like to connect after the training, that would be great. I like to post updates about sanctions on my LinkedIn, and I'm always happy to answer questions if you have any. So what I'd like to do today is to provide an overview of these recent guidance documents. Try to put them in context by describing what the role of guidance is in sanctions regulation and how it impacts participants in the market. I want to talk about the key takeaways from these two guidance documents, and then I want to look at some case studies and examples to illustrate the principles and how they've arisen in real life. Finally, I'd like to leave as much time as I can for questions and answers. I would really encourage you to use the Q&A box. If we're not able to get to every question on today's session, we'll try to follow up and get you an answer. So here are the stars of the show. On the left, we have the US government's May 2020 guidance, which we'll talk about in some detail. On the right-hand side, we have the UK government's guidance from the Office of Financial Sanctions Implementation. The one from the US government's about 35 pages long. The one from the UK government is about 12 pages long, but they have a lot in common. And if you ask me, they represent the culmination of a couple of important trends and the intersection of those trends. The first of those is the fact that sanctions regulation and enforcement is increasingly looking away from the financial sector and focusing on actors in the corporate space, and particularly in transportation, both in maritime but also in aviation. The second is the emphasis being placed on compliance and the increasing amount of guidance that enforcers and regulators in various countries are offering to help companies understand sanctions, how it may apply to their business, and how they can build robust compliance programs in order to address their risk. Now, when I talk about risk, I really want to talk about it in 4 different dimensions. There's something that we call designation risk. That's the risk that you might end up on a sanctions list, like the list of specially designated nationals or the SDN list. The second is an enforcement risk. I think that's the one that most people think about as being relevant to them. That's the risk of an enforcer actually bringing an administrative or criminal action against you that could lead to a financial penalty. The third is related to that, and it's an investigation risk. I think this is often overlooked. Even if somebody doesn't end up on the front page of the newspaper, they can be investigated. And the time and the expense that goes into addressing those requests for information from governments, it's tremendous. And I think if companies knew what an investigation entailed, I think they would take greater steps to avoid them. And finally, there's counterparty or commercial risk. And we'll talk about some examples of how participants in the market are actually taking on board these guidance documents and other requirements and imposing them in a way on their counterparties. So before we get into the nitty-gritty, we'll do a poll question. So I'll ask the Windward team to display that, please. And the question is, in your organization, which teams are involved in addressing these new standards, like the ones that I've just mentioned? Is it your compliance team, operations, business, IT, or legal? You can select more than one answer. Try to think about who would really take on responsibility for leading change in your organization in response to these new standards. Who are the key teams? If you could just put in your answer in the polling box, we'll collect those and then display the results. And here we go. Well, I'll tell you, we did a session earlier today, and in fact, the results were very similar to what I'm seeing here. So I think we've struck on something. About 80% of you have said that compliance will lead the charge, followed by legal at number 2 with 67%. That's about what we received earlier. So I think that's consistent with my understanding. Compliance and legal obviously would be responsible for monitoring the environment and bringing those requirements into the organization. A fewer numbers selected operations and business at 38% and 28% respectively. and only 11% chose IT. And in fact, I think we had 11% earlier today as well. That's an interesting finding, because increasingly sanctions compliance is about technology, and so IT should play a very important role in this process. So thank you for participating in that poll. Why don't we go ahead and get into some detail. The first thing I want to do is set the stage and talk to you about the role of guidance in sanctions regulation. As a lawyer, I often get the question, what do I have to do about this guidance? Am I required to implement these steps? And the answer is not really. Guidance is not law in and of itself. It is a way for regulators to express their expectations for how we can go about complying with the law. But you don't need to follow the guidance to the letter. It is more or less a suggestion which is being offered. And if you read the US government's guidance and the UK guidance, you'll see that they both include that caveat. What they're doing here is providing us with some interpretation of what the law and regulations mean. That could include definitions or even exceptions to the regulations. And they're really filling in the gaps. The regulations can sometimes be vague, a little bit capacious. So these guidance documents help the regulators put things into more practical terms. They can provide alerts to the public on trends or typologies. Those are patterns of behavior that can indicate risk. And what is interesting is that when there are sanctions designations or enforcement actions, regulators will often point back to guidance that they've issued in the past. And they will tell us that these designations and enforcement actions prove their point. While they are not strictly law and they are optional in many ways, the regulators can say, I told you so, if you chose not to follow the guidance and later found yourself on the receiving end of an investigation or enforcement action. So it is important to take heed of them, to think about how they apply to your organization, and to do your best to incorporate them, because if you do find yourself in that situation, having really taken these guidance documents on board will do you a big favor. So why don't we look at the two guidance documents in a little bit of detail and try to understand what they're saying. The first is the US guidance to address illicit shipping and sanctions evasion practices. This was issued earlier this year in May. It's provided by the US Treasury Department, State Department, and Coast Guard. For your information, the Treasury and State Department are responsible for identifying sanctions targets, for example, individuals and entities that go on the SDN list. Treasury Department is responsible for enforcing those sanctions. The Coast Guard, on the other hand, is also a law enforcement agency in US domestic waters and in some cases international waters. But more importantly, in this case, it is a subject matter expert. And I think if you read this document closely, you'll see that there's a lot of knowledge, expertise, and context that's been baked into it. I think it's a really informative and educational document. What you might also notice about it is that it is focused on the energy and metals sectors. It talks about risks associated with petroleum products, coal, sand, metals, and other similar commodities. It's not really concerned with other types of shipping like cargo shipping, things of that nature. It is focused on these higher risk goods. What is nice about it is that it addresses itself to a very broad audience. You can see examples that are listed here. Shipping industry associations, ship owners, classification societies, even vessel captains and crewing companies. I think for some of these parties, it was the first time they had ever been addressed directly in a guidance document. They may have been surprised by it, but it is a very detailed and practical document which provides a lot of useful information, as I said. One of the things that it focuses on is identifying deceptive shipping practices. And what it's telling the maritime community is you need to have a risk-based compliance program that is designed to pick up on these indicators so that you can take further steps to understand what's happening and, if necessary, take measures to protect your organization from risk. Some things that it points out: number one, disabling or manipulating the AIS system on vessels. I think everybody on today's webinar has heard a lot about this. I think our friends at Windward could educate us more on AIS practices. They also talk about physically altering vessel identification. That means literally painting on the side of the boat. Falsifying cargo and vessel documents. Ship-to-ship transfers. That's also a very important concept. It's been in the news a lot. Voyage irregularities, false flags and flag hopping, and complex ownership or management. And what the US government is saying here is not that all of these activities are necessarily indications of sanctions evasion. What they're saying is that they're indicators, that in the past they've been identified with cases of sanctions evasion, and they're recommending that the community keep an eye out because these could be indicators of risk. They also provide some helpful recommendations for practices for identifying sanctions evasion. So in other words, they point out what some of the potential risks are, and then they provide some recommendations for addressing that risk. The first is institutionalizing a sanctions compliance program. They refer to another document, which is called the OFAC framework, the OFAC framework for OFAC compliance commitments. It's quite a mouthful, but it's a very useful document that breaks compliance programs down into 5 pieces and basically provides a blueprint for building a risk-based compliance program for any type of organization. So they encourage that kind of risk-based compliance. There are recommendations for establishing AIS best practices and including contractual requirements for keeping the AIS system switched on. The importance of monitoring ships throughout the entire transaction lifecycle to make sure that they are behaving as expected. Know your customer and counterparty due diligence. Of course, that's very important, not only for financial institutions, but any kind of corporate party. And the reason for doing this is not only to really understand who your counterparty is and who their beneficial owners are, but also to collect information that could be useful in a future investigation if needed. Supply chain due diligence, obviously important. Contractual language in order to notify counterparties of their expectations. And I think a key bullet is industry information sharing. I think the whole spirit of this guidance document is making sure that the industry is talking, is sharing information and best practices, and that these risks are being highlighted and dealt with in a cooperative nature. I did want to call attention to the specific guidance that's provided for financial institutions. What I like about the US document, it is lengthy, but the reason for that is that it contains an appendix that goes segment by segment and provides some specific recommendations for addressing sanctions evasion risks. For financial institutions, the list is not very long. This document does not focus on financial institutions. It focuses on other aspects of the maritime community. And as I said, that's one thing that makes it very unique. But for financial institutions, the recommendations, I think, are not that surprising. I think a lot of financial institutions have these elements baked into their AML and sanctions programs. And so this document is really reiterating something that we already know. For example, considering high-risk commodities and trade corridors. These are issues that have been highlighted in UN panel reports and lots of shipping advisories in the past. Assessing the nature of a client's business, including their services and their geographical presence. That's basic know your customer kind of stuff. But of course, monitoring client activity for those transactions that are inconsistent with what you know about the customer. And this last bullet is interesting, scrutinizing acquisition or sale of vessels. And specifically what the document says is that you should be identifying blocked property. that would be property which is owned by a sanctioned party. And finally, the document reminds financial institutions that they may have an obligation in their home jurisdictions to report suspicious activity to a financial intelligence unit if they believe that there may be, for example, trade-based money laundering or other kinds of illicit activity that would require reporting. So this is not simply a sanctions compliance issue. There's a huge component of AML compliance that goes with it. The guidance does focus on 3 countries in particular: North Korea, Iran, and Syria. I put Venezuela in parentheses because I believe if they would have issued this document today, they probably would have mentioned Venezuela. There's been a lot of activity recently with Venezuela and the shipping sector. I should also mention that North Korea, Iran, and Syria are subject to comprehensive US sanctions. That includes pretty much blanket ban on trade by US persons with certain exceptions. Lastly, what I wanted to point out just for reference and for your information, and I do this because I noticed that there's often some confusion about the scope of US sanctions, particularly on Iran. And so I use Iran as an example here. Not everything having to do with the country is strictly prohibited. And there is some flexibility in the US regulations. The regulations tend to focus on particular types of activities, especially when we are dealing with secondary sanctions. I think that's sometimes forgotten. What I wanted to remind everyone is that in the Iranian Transactions and Sanctions Regulation, ITSR, it is noted that US persons are not strictly prohibited from dealing with vessels that merely pass through Iranian waters or stop at Iranian ports. You need a little bit more than that in order for the regulations to kick in. In particular, you need to be dealing with goods that have entered into Iranian commerce somehow. That's something that a lot of financial institutions overlook. They tend to have very, very strict policies. I just want to remind everyone that the regulations are a little more nuanced than that. There are also a number of FAQs which deal with different issues that help to color in how these regulations work, and in particular, how secondary sanctions work. The ones I pointed to are numbers 296, 691, 692, and 315. You can Google these and find them pretty easily, but I want you to notice what they're focusing on. First, it's bunkering, so providing services to non-Iranian vessels that are carrying non-sanctionable goods to or from Iran. Basically, what OFAC says is that those are relatively low risk for secondary sanctions. But then we start to move up the scale. 691 tells us that if we're dealing with a non-Iranian vessel that is carrying sanctionable goods, such as petroleum, well, that's going to be a different level of risk. That will be higher. And then, of course, the highest would be Iranian vessels themselves. Lastly, there is, again, a tolerance in the secondary sanctions program for routine payments to port operators with respect to non-sanctionable goods. So again, keeping in mind that there is some flexibility in the regulations. When we're looking for risk, we really need to be focused on the type of activity that we're dealing with. So that's the US guidance in a nutshell. Now I want to turn our attention to the Office of Financial Sanctions Implementation, or OFSI. Now, like the US guidance, this document is addressed to a wide audience. You can see some of them listed here. It's pretty similar to what the US guidance document is attempting to do. But of course, this is going to be framed in terms of UK law and regulation. Now, one of the reasons this is so critically important is because the UK is moving towards Brexit by the end of the year. And as a result, I believe that the OFSI will become increasingly important. We did recently see a fairly large settlement involving a UK-based financial institution. And I think that really put everybody on alert that this is a serious enforcer and that they intend to be very, very active. I think this guidance document is yet another example of how they're doing that. So here are some key points. Like the US guidance, there are examples given of potentially risky activities. These include, again, ship-to-ship transfers, manipulation of AIS, and so on. But the UK document also draws attention to cyber activity and crypto assets. This is not mentioned in the US document. It's an issue that's been highlighted with North Korea in some UN panel of expert reports. And so it's been addressed in this document. I don't think we normally think of cyber activity and the maritime sector as crossing over, but in fact, there have been some significant examples. There's also a belief that North Korea in particular uses cyber theft as a way to fund trade, which of course is carried on vessels. Financial system abuse, of course, is an important topic. False documentation, which is also mentioned in the US guidance document, and concealment. That could be concealment of ownership or the nature of goods, so on. Now, like the US government's document, the UK document also focuses on specific countries. It doesn't mean that this guidance wouldn't apply to other country programs. These are the ones that they highlight. It also includes North Korea, Iran, and Syria, just like the US document, but the UK document mentions Libya as well. It points out that the Libya program, the EU Libya sanctions, include a lot of vessels that are on the list. And what distinguishes the UK guidance from the US guidance is these programs are not comprehensive. So the US has comprehensive sanctions, which, as I mentioned, operate as an almost total trade embargo against these territories. The UK takes a list-based approach, which means that what we're looking for really is the involvement of an individual or an entity or a vessel, which appears on a sanctions list. Now, the way that that is expressed is through ownership and control. So not only are we looking for the entity which is on the list, but we want to know if our counterparty is owned or controlled by somebody who is on that list. So what the document does, it repeats some criteria which can be found in other UK guidance. It mentions that ownership and control can be indicated through a holding of more than 50% of shares or voting rights, the right to appoint a majority of the board, or the ability to influence the actions of the company or to control its assets, and the right to exert a dominant influence over the company. If you have these indications and there appears to be a sanctioned person behind the company that you're dealing with or behind the vessel that you're dealing with, if you are subject to UK regulation, you may be prohibited from providing economic resources or funds to that vessel or that company, whatever the case may be. And you may have other obligations such as reporting to the OFSI. This is different than the US system. The US system tends to focus only on ownership rather than ownership and control, with a few exceptions. So I think this is an important part of the guidance and something to reflect on, because I think it means in some ways you have a higher standard when you're complying with the UK sanctions than with the US sanctions, at least when it comes to this issue. The document also outlines due diligence practices very similar to the US guidance. One thing they have in common is that they suggest a risk-based approach. What that means is that you apply your efforts and your resources to the areas of highest risk. It's a common sense approach, but it does require you to perform a risk assessment. So you look at your business, your counterparties, your products, your geographies, and you try to get a sense of where the risk might be. And then you apply more resources to areas of higher risk. The document is very, very clear that they do not mandate any specific measures. So these are recommendations, they're good practices. As I said before, they're not mandates. And so in some ways they are optional, and you could even go beyond them and invent other measures. Some examples they give is understanding sanctions regulations to know how they apply to your business, watching for AIS manipulation and including switch-off clauses in your contracts. When you do notice some kind of unusual AIS behavior, making an inquiry to the vessel to see if there's a reasonable explanation. Using subscription-based or open source information to perform due diligence, scrutinizing documents for sign of fraud. And again, like the US document, information sharing is encouraged. I think that's a key theme. I think it's part of the reason why we're here today and why this will be an ongoing conversation. So here's just a little chart comparing and contrasting. You can see that they're actually very similar. It applies to financial and non-financial companies in both cases. Both indicate a risk-based approach and encourage due diligence as part of compliance. There is the possibility for both administrative and criminal liability. What I mean by that are monetary penalties as well as criminal penalties, which could include imprisonment for individuals. And in the case of secondary sanctions, I think this is the big difference between the US sanctions and most other sanctions is that the US does use secondary sanctions extensively, whereas the UK does not. So before we get into some case studies, we have time for another polling question. And this one is, in your opinion, what do you think are the main challenges in meeting the new standards that we're talking about tonight? Is it training, personnel, upgrading technology, obtaining data, getting buy-in from business, understanding typologies, or clarifying regulators' expectations? Again, you can select more than one answer. I'll give everyone just a moment before we discuss that. All right. Again, very interesting because these answers are very similar to what we saw earlier today. The number one answer is obtaining needed data. And I mentioned earlier today that I thought this was interesting because when we did the earlier polling question and we talked about the team that was leading, IT was in last place. And I think if we're talking about data, there might be an opportunity there to work with our IT teams to see if we can get more quality data for our compliance program. Training is obviously an important need. That's the next highest, very, very close in fact. Training is important, and I think that's part of the reason why we're together today. So I hope that this is the first of many trainings for you. Technology and clarifying regulatory expectations are next. Then understanding typology and getting buy-in from business is last. And actually, earlier today, this was also last. I thought that was good news because it looks like most of you are not having problems getting buy-in from your business. It seems about 70% of you are okay there, which is great. Once you have the business on board, the next task is building a strong compliance program. So once again, thank you for sharing your thoughts. I appreciate that. And now we'll look at some examples before we open up for Q&A. Now I'm going to go through these fairly quickly. I would encourage you to Google them if you're interested to read a little bit more. Some of them you may have already heard about. But as I said earlier, what I'm trying to do here is illustrate the different ways that these issues have come up in real life and how we can have both a governmental risk and a commercial risk at the same time. I also want to point out some key patterns of what happened in these cases so that you can see exactly what led to the outcome. The first one is a pretty famous case, actually. It's the Adrian Daria 1 or the Grace 1. This was in August of 2019. The ship was suspected of transporting petroleum from Iran to Syria, and more importantly, it had links to the Islamic Revolutionary Guard Corps, or IRGC, that is designated as a terrorist organization by the United States. As a result of that, the U.S. has power under U.S. law to issue seizure orders against property of terrorist organizations, and that's exactly what happened here. the Department of Justice obtained a forfeiture order from a US court and attempted to seize this vessel when it was in the port in Gibraltar. A judge in Gibraltar decided that because this was not an EU issue, meaning EU sanctions, they were not able to honor that seizure order, and the vessel ultimately moved on. But the captain was designated as an SDN as a result, as well as the vessel. But I think more importantly is what happened in September of last year. OFAC ended up designating a shipping network that was connected to this vessel, and it was not an Iranian group. They were based in India. This is the Mehdi group. They also have offices in the UAE and Singapore and entities in the Marshall Islands. They were also designated under the Terrorism Authority. The idea here is that companies which are operating vessels engaged in high-risk activity involving SDNs and high-risk commodities between sanctioned territories are obviously in the line of fire when it comes to sanctions designations, and that was made clear in this case. Next, we look at North Korea and a vessel called the Shangyan Bao. This also was in August 2019. This is a Taiwan-based company. 2 individuals, 3 companies, and a vessel all put on the SDN list. What is important to take away from this example are the typologies that were being pointed out by the US government. In particular, the company falsely reported that petroleum on their vessel was destined for the Philippines, but in fact, when the vessel was tracked, it was seen that it had gone to international waters and engaged in ship-to-ship transfers with North Korean vessels on 2 occasions. So we have unusual activity, and we also have fraudulent documentation. Those were risk indicators that were mentioned earlier. The Wise Honest is another North Korean case. This was in May 2019. This vessel was seized in Indonesia because it was suspected of violating UN sanctions. It was carrying coal from North Korea. It would trade the coal and load up with heavy machinery, which was then taken back to North Korea. One of the features of US law is that if property outside of the United States is linked to violations of US money laundering or sanctions laws, again, the US government can seek to seize that property. That happened in this case. Funds that were for the operation of the vessel were transacted through the US financial system in violation of US law. The DOJ obtained a forfeiture order and actually in this case was able to seize the vessel and then sold it for scrap. Again, the indicators in this case were pretty blatant. Not only did we have those payments that were going through the US financial system, but this vessel was operating without transmitting an AIS signal from August 2017 to April 2019. Additionally, like in the other case, shipping documents which were obtained by the DOJ listed fake ports of loading and also fake nationalities for the vessel. There was also attempts to disguise the ownership of this vessel. The next example is secondary sanctions risk. This has to do with Iran, and in particular, an Iranian company called the Islamic Republic of Iran Shipping Lines, or IRISL. It's very important when you're performing due diligence to try to identify vessels which are owned or operated by IRISL, because the US government has designated it under a authority which allows for secondary sanctions. Now, in this case, the Chinese company, which was added to the SDN list under the secondary sanctions, was transporting graphite to Iran on board a vessel operated by IRISL. So again, we have this intersection of many high-risk elements. We have graphite, which has been identified by the US government as a metal which is subject to secondary sanctions. We have the involvement of the territory of Iran. We have IRISL, which is a sanctioned shipping line. As a result, the company was again put on the SDN list, and the State Department took the opportunity to remind the world about these secondary sanctions risks. Similar to this is Costco Dalian, another famous case from 2019. This was two subsidiaries of a major Chinese shipping line, which were placed on the SDN list under a secondary sanctions authority for transporting petroleum from Iran. Petroleum, again, a commodity which is subject to secondary sanctions. Iran, once again, a high-risk territory. Ultimately, one of these entities was removed from the SDN list, but the other one continues to be on the SDN list. I think this gets to concerns about supply chain due diligence and keeping an eye out for sanctioned vessels and vessels which are owned by sanctioned shipping lines. Now, this is what I alluded to earlier, having to do with Venezuela. What is interesting is there's been a development in the past few months where we're seeing more shipments of petroleum products from Iran to Venezuela. The US government has been very aggressive in addressing this, and I've included two examples here. The first was from June, when 5 individuals who were captains of ships operated by Iranian companies were put on the sanctions list for taking petroleum products from Iran to Venezuela. So again, the shipping lines were already sanctioned, so OFAC went after the individuals who were the captains on the ship. Now, the next example is from August, a little bit more recent. There were 4 vessels which were heading to Venezuela carrying, I believe it was gasoline from Iran. The DOJ was able to convince the owners of the vessels, I believe it was a Greek company or several Greek companies, that this was potentially going to lead to sanctions for them. They were persuaded to turn that gasoline over to the United States. It was taken to Texas, and I believe it's being sold. Once again, the reason they were able to do that is because the gasoline was linked to the IRGC, which is designated as a terrorist organization. So this is a similar issue as what we discussed with the Grace 1. That was the first example I gave you. Now we're going to shift gears a little bit and talk about commercial risk. The next 2 examples are taken from the media. I like them because they illustrate that it's not only the government that is enforcing these rules. The first example involves 2 gas tankers, the Gas Infinity and the Gas Dignity. These were held up in Singapore at the request of a German lender. The German lender alleged that the owner of the vessels, to whom the lender had provided a mortgage, were breaching their agreement because the vessels were used to transport Iranian liquefied petroleum gas. Now, how did the lender learn about this? Well, they were informed when the P&I Club terminated coverage, and the P&I Club had learned about it from media reports. And the media reports cited some information suggesting that the vessels were engaged in Iranian trade. In particular, they had switched off their AIS near a high-risk zone. They turned that system back on after several days and were laden with cargo, and they were engaging in ship-to-ship transfers in Asia with vessels that then would transport the product to China. So it was a complicated vessel movement, AIS behavior, and so on. And under the agreement, that provided the lender an opportunity to invoke the clause and attempt to seize the vessels as security. So again, it's not always the government. In this case, it was a lender who had learned about something as a result of a media report. And last is a more recent example from August, a vessel called the Alkimos. This again has to do with Venezuela. According to Bloomberg, the owner of the vessel had chartered it to a Panama-based company, which was transporting gasoline from Panama to Aruba. Later on, the vessel's owner learned that the charterer intended to transfer that product to another vessel, and that second vessel was linked to PDVSA, the state-owned Venezuelan oil company, which is on the SDN list. Well, the vessel's owner thought that was pretty high-risk activity, didn't want the vessel involved in it, so exercised a lien over the cargo, directed it to Texas, where it was seized and sold at a heavy discount at a court auction. So again, this was a case where the owner of the vessel learned of the high-risk activity, took steps to put a stop to it. That was an interesting case that I read about and felt that I should share with you. So those are the cases. Those are the basic principles. I tried to talk a little bit about what the guidance is for and what it's focused on. And then you'll learn in the remaining 2 trainings about how compliance and risk can be addressed in your organizations. So with that, I'd like to open it up to questions. It looks like we have about 15 minutes. So I would ask the Windward team to please read off those questions when you're ready.
Excellent. Thank you, Mr. Turner. This was fantastic. Before I read the questions, I just want to let people know that we shared an executive brief that goes into more detail on the sanctions deceptive shipping practices, and there are more case studies on our website, including some of the ones that you discussed. So we're going to start with one of the questions. In reinsurance treaty business, the reinsurer only receives limited information on underlying insureds. What steps do you think they should take to meet guidance objectives?
Right. I think this raises an important issue, which is about the level of information that we have in order to conduct our compliance. Reinsurance is a great example. You're not going to have as much information as other parties are going to have. And regulators and enforcers understand that. The rule of thumb is that you should use the information which is available to you in the ordinary course of your business. You're not necessarily required to get extraordinary information simply for the purpose of conducting a sanctions review. That being said, when you do receive information, you're expected to review it based on a risk-based approach. And if you do see indications of risk, that's when you would raise it with your counterparty. In reinsurance in particular, the contractual clauses are very important. They're often framed in terms of exposing the parties to risk of either designation or enforcement. And again, when you receive information that provides you some insight, whether it's to a territory or a type of counterparty, an SDN, whatever the case may be, that's when you should raise it with your counterparty. But keeping in mind that some of us are going to have more information than others, and that's a normal part of the business.
Thank you. The next question is with regards to the U.S. requirements. Is there a U.S. requirement to screen for ownership and control? Is it limited to vessel owner beneficiary?
Sure. So first of all, and I know this sounds a little bit tricky, but there's no requirement to screen at all. The requirement under U.S. law is not to breach the sanctions, and you can go about that any way that you would like. And most companies choose to do screening. They do it because it's effective and because it's something that you can build into your program, into your processes. Now, when it comes to control, usually under US sanctions, we're focused on ownership. And usually what that means is we're looking for entities or vessels, whatever the case may be, that are owned 50% or more by one or more SDNs. That's something that you can screen for fairly easily, because you can collect beneficial ownership information and then screen that information. Now, control is a little bit more tricky because you're not always going to have a clean overlap between beneficial ownership and control. But thankfully, in the US system, that's not a key issue. Where it does come into play, though, is when we're looking at sanctioned governments. So that could be Iran or Syria, it could be Venezuela. Or if we're looking at vessels which are owned or controlled by Iranian SDNs, that can lead to some risk. Usually, what the US will do is if it becomes aware of an entity which is controlled by an SDN, they will usually put it on the sanctions list if they intend for it to be subject to the restrictions. Otherwise, most companies tend to rely on their commercial providers to do that kind of research. But that's a long-winded way of saying there's no strict requirement. It is a risk-based approach, and ordinarily we would just focus on ownership, not control.
Thank you. The next question is with regard to ship brokers. Are you seeing much OFAC or DOJ enforcement interest in ship brokers?
I'm not aware of any specific examples that I can talk about here. What I can say is that the US government is very interested in tracing the ownership of vessels. And if you pay attention to the enforcement actions and the indictments that are coming out, there's a lot of information given about steps taken by the enforcement subjects to obfuscate the ownership of vessels. And to the extent that any parties involved in that process, I think they would be of interest. What I've noticed, which I can say in general terms, again, I can't share any specific examples, is that especially when it comes to petroleum, coal, and those kinds of commodities, the US government is interested in intermediaries, trading companies, shipping companies, vessel operators, anybody who may have been in a position to know that the goods that they were handling were destined or originated from a sanctioned country. They're very, very interested in making sure that people are thinking about supply chain risk, and if they have any indications that their counterparties might be involved in that activity, that they're taking steps to protect themselves. I've seen a lot of investigations where parties inadvertently find themselves in the middle of something because they didn't take steps to clarify who they were doing business with.
Okay. When it comes to shipping, as you mentioned, ship-to-ship, STS, transfers occur regularly. With respect to investigation, how far are firms required to go?
Sure. It depends on the case. It is a risk-based approach. Again, there's not a quote-unquote legal requirement to investigate it. What you're looking for are indications that a vessel was operating unusually. In the case of a ship-to-ship transfer, was in proximity to another vessel which had some kind of a risk to it. Again, these are things that Windward are great at spotting. And whether or not there's other indications around the transaction of something suspicious. It could be unusual documentation. It could be documentation which doesn't match the vessel's behavior, like in the example I gave earlier of the vessel which was supposed to go to the Philippines but didn't. And also, anything that you can find about the ship's operators that may point to a potential risk. So you kind of look at the whole constellation of facts to see if there's a number of risk indicators. If there are, then I think the next step is to go to the relevant parties and to try to get information from them about what's really going on. And if you can't square the facts, that's when you might have a problem. If, on the other hand, you get to a reasonable explanation, that's often sufficient.
Okay. And the next question is actually regarding a lender. What are the implications for a lender doing business with an entity or individual that gets sanctioned after the lending relationship is initiated?
Well, let me put it simply, it's a mess. The lender obviously has a lot of commercial risk in that situation. If you have an asset or a counterparty who's sanctioned, especially by the US, that property is subject to blocking when it's in the United States or it's within the possession or control of a US person. Any transaction in relation to that property also may not involve US persons, and that includes the US financial system. So if you have a US-based lender, they more or less have to get permission from OFAC in order to receive payment on that debt or to try to enforce the debt. If you have a non-US lender, their issue is that they can't use the US financial system in order to make or receive payments in relation to it. So it is very complicated. Depending on the situation, it can be worked out. Generally, if you can take steps that are outside the US, outside of the US financial system, not involving US persons, there's ways of dealing with it. But otherwise, you would have to go to the regulator and try to get some licensing in order to unwind that situation. But it is complicated.
Okay, I think we have time for 2 more questions. So this one is, in practice, it is almost impossible for a ship owner to obtain charterers' beneficial ownership information. Certainly, most charterers are not willing to share this information. Importantly, as far as I'm aware, no subscription service is able to identify beneficial owners in third world countries. How can owners protect themselves in these situations?
Well, that isn't an issue that the guidance documents address, unfortunately. They do encourage getting beneficial ownership information. They even say that it should be a photo ID. I think financial institutions in particular always have this challenge when they're trying to get beneficial ownership information. But at a certain point, if it's a situation where there appears to be risk, again, a risk-based approach would suggest that you have to draw the line somewhere. And if the charterer is not willing to provide information that you need as part of your process, then that's probably a time to make a commercial decision about whether or not you can move forward. Otherwise, as you suggested, if you have third-party information, occasionally that's helpful. But it's usually better to get that directly from the party. I think increasingly, parties understand that this is becoming more of a requirement or an expectation, and so they're having to provide that information. And I think that's part of what this effort by the regulators is all about, is getting people used to the idea, improving practices across the board, sharing information, and trying to raise the standard over time.
Okay, and this is the last question. Do you find the technology and intelligence offered from vendors to be significantly more important from an investment standpoint in maritime versus the overall sanctions compliance environment?
Oh, I think so. Now, the reason I say that is because, my opinion is that, first of all, sanctions compliance, after you know the basic rules, it's pretty simple. It's a basic directive, just don't do business with a sanctions target. I think that's pretty simple. The problem, though, is that there's so many transactions and so many parties, counterparties all the time, that you need a technology solution to deal with all of that volume. So that's name screening, due diligence tools, vessel tracking, those sorts of things. The reason that companies need to make those investments is because you need to build a compliance program that has consistency, that is pulling in relevant data points and is organizing that information so that you can make quick decisions and you can bring down your operational requirements. The better technology you have, the fewer operational resources that you need to sift through this information, and your attention can be drawn to where your risks really are. I think the key to the risk-based approach is that we focus on where our risks are, and if we have a technology available that helps draw our attention to that, I think that's what the risk-based approach is asking for. And I think it's better than trying to pull together from open sources, all of the things that we need in order to address the problem correctly. So if you ask me, I think it's very important to look to technology vendors who can help us solve problems.
Okay, great. Well, that was the final question. If we didn't get to your question, no need to worry. We'll be in touch with an answer in the coming days. We'll also be sharing a recording of the session. Save the date for the next session, taking place September 22nd at the same time. So that will be 9 a.m. UK, 4 p.m. Hong Kong, and 9 a.m. Eastern, and 2 p.m. UK. It will feature Leigh Hansen and Alexander Brandt leading the sanctions and export practice at Reed Smith, The topic will be developing a risk mitigation framework, so it will build on this session's topic. You will receive a reminder email with instructions how to join. Once again, thank you, Mr. Turner. This was fantastic. Hope to see you all again soon. Stick around for the survey. Have a very great morning, afternoon, evening, wherever you are.
Bye-bye.
Bye.